May I now request Ms. N. Krishnaveni, Senior Advocate, Chairperson of the Lexicon, to the dais. May I now request our guest speaker, Honorable Mr. Justice N. Anand Venkatesh, to be escorted to the dais. I invite our C. Prithviraj to honor the guest speaker with the moment. I invite Mr. A. Chilambarasan to adorn the guest speaker with a traditional song. Thank you, Lordship. Thank you, sir. On behalf of MMBA, I would like to share a few words about the guest speaker. Honorable Mr. Justice N. Anand Venkatesh is the first generation lawyer. His Lordship has rich experience in the trial side and is well versed both in civil and criminal law. His Lordship is the jack of all trades. He has practiced on the original side, appellate side, criminal side and writ side before the Madras High Court. His Lordship has also handled service matters before the Central Administrative Tribunal Chennai bench. His Lordship was appointed as amicus curiae by the High Court on several occasions. His Lordship was a part of the consultation and drafting committee which suggested various improvements in the realm of commercial litigation all over the country, which led to the enactment of the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015. His Lordship's seminal verdict pertaining to upliftment of LGBTQIA plus community in Mrs. S. Shushma and others versus the Director General of Police and others has been an ardent decision in the history of our Indian judiciary. In this case, His Lordship has directed the state to compile a glossary on how the LGBTQIA plus community people should be addressed in the society. His Lordship has also written a number of articles in the reputed law journals, and recently he has authored a book on the revised 14th edition of Mulla Transfer of Property Act along with Honorable Mr. Justice V. Lakshmi Narayanan. This book focuses on the impact of contemporary developments and key judicial decisions on the law of Transfer of Property Act. This book also details certain non-glossary terms pertaining to the Transfer of Property Act.
Consent means agreeing or accepting to do something. No man is good enough to govern another woman without her consent. Sexual consent is entirely depending on understanding of partners. But the consent is inadmissible when it is given by an adolescent. Nevertheless, we are witnessing so many cases relating to adolescent sexual consent. Cases of this nature are increasing day by day. Whether it is harmful to the society or not is highly debatable. Contemporary society opens the way for teenage sexual relationship. Right to life and liberty, as guaranteed by the Constitution, is equally available to the minors. On one hand, protecting the right of adolescent. On the other hand, state's responsibility to protect adolescent from sexual exploitation. We have to strike a balance between the two. How to do, what to do is $1 million question. More understanding, interpretation, and in-depth knowledge is the need of the hour. In order to throw limelight in this emerging area, a bar-friendly judge who has handled plethora of POCSO cases and recommended separate committee for dealing with the POCSO cases is here. Let us be ready to be enlightened on the topic of this session. With this, I would like to request Honorable Mr. Justice N. Anand Venkatesh, Judge, Madras High Court, to deliberate about the intrication regarding adolescent sexual consent and POCSO.
Good evening to all. Now there is one exercise which we have to do before I proceed further. So when I say one, you will have to clap once. When I say two, you will have to clap twice. Then when I say three, you will have to clap thrice. After the end, I will tell you why I made you do it, right? 1, 2, 3, 2, 1. See, what happens is, if you do it, the blood flows. So when the blood flows, you will come out of your sleepy tendency, because I am delivering it after lunch. I do not know what Srinivasa Raghavan had in his mind when he did this, but it looks like he had some axe to grind against me. So he gave me the last session when all of you are already tired. So I'll have to make it somehow exciting. And with the high level of topics that were discussed by erudite speakers, at the end of the day, in any serious cinema also, you need a comedian just to excite you, just to make you lighter, and that comedian is the one who is standing just before you. So with this, I think all of you have woken up, so I'll go forward with this. I thank MMBA for inviting me, and to really stand in the midst of the youngsters gives you a lot of energy, and to make me talk in the midst of some erudite speakers who have already addressed here, meaning the response that they were getting, even they were so erudite that I was feeling a bit jittery to really stand here and talk here. Anyway, you have no other go, you will have to listen to me for the last 30 minutes or so. Just bear with me. I will try to make it as interesting and as involving as possible. See, India is one of the youngest country in the world now. India today has 31% of the total population under 18 years. That is why world countries are fearing looking at India. That's exactly the reason why they fear India, because in many countries, even including China, the amount of money that they are spending on pensioners is going more than what they are able to earn by making people under that age to work. So it's becoming so disproportionate, and whereas in India you have a 31% population of persons under 18 years of age. So with this population, keeping in mind this population, you are bound to have children who will either be in conflict with law, as it is defined under the Juvenile Justice Act, or you are bound to have children who are in contact with law, namely the victims of, or the survivors, or the witnesses of crimes. So you will have a big population of it. So that's very peculiar because of the large population which we are having in such a large country. So we needed a child friendly justice, for which Justice Jain was talking about Article 15. Article 15 specifically touches upon provisions and policies for the benefit of children. So that's the source of power from where all these are emanating. There are basically three core categories of children whom we are involving here. There are three core categories of children. The first are the core categories of children whose rights are involved. I will put it that way. Whose rights are involved here. The first category is the survival rights. One is survival rights. Survival rights is right to be born, right to good food, right to shelter, right to clothing, right to good health, etc., etc. These are all survival rights of the children. So, for example, if you want to bring some act in it, you have this Prenatal Diagnostic Regulation Act. Just one example for this right which is being safeguarded. There are lots of other enactments, but this is one example which I want to give. So the first core right is the survival right. The second right is the development right. A child has to develop. Development right, as you all must be knowing, it will cover right to education. You educate yourself for developing yourself and to get ready to compete in the society, to come up in the society. So what is the basis for it? Again, go to Constitution. Now it is guaranteed under Article 21 capital A of the Constitution of India. You have the Right to Education Act. This is just an example which I am giving. And the third right, third type of right, the core right, is the protection rights. under the protection right, these are the protection from neglect, protection from physical, sexual abuses, etc. This is the third core right which a child is entitled to, and it is under this you will have the Guardians and Wards Act, you will have the POCSO Act, you will have the Child Marriage Restraint Act, then you will have the Juvenile Justice Act. All these will come under this third category. So it is this third right. What the first one is survival rights, the second is the development rights, the third is the protection rights. It is this protection right which will be our focus for today's discussion, where we are going to specifically touch upon adolescents. What is the genesis of this act, of this POCSO Act? You will have to understand this genesis. I am not going to really bore you with a lot of, by reading provisions and all that, I will not do it. Genesis of the act is that you will find that there was a UN convention on the rights of the child. This was ratified by India, and this UN convention was ratified by India in the year 1992. 1992. It stayed there. Then there was a case which was brought up before the Supreme Court, which everybody knows is the Sakshi case. Sakshi case was the reason behind this enactment itself. So the Sakshi case, if you want the citation, it is 99 6 SCC page 591. Sakshi case. So that Sakshi case is an NGO who filed a public interest litigation before the Supreme Court, and they brought to the attention of the court that the existing provisions under the Indian Penal Code are not really taking care of the sexual harassment, sexual abuse, violence that are perpetrated against children. So therefore they were pushing for a separate enactment to deal with it. The existing provision under the Indian Penal Code was not really helping. And this was the purport of filing this public interest litigation before the Supreme Court. And eventually the public interest litigation was disposed of after 5 years after it was filed. And the Apex Court basically requested the Parliament to come up with a law to deal with issues pertaining to sexual abuse on children. So after this direction was given, the POCSO bill was tabled in the Parliament, and it was referred to a standing committee. The standing committee submitted its 240th report. This came under the 240th report, and while doing it, the attention of the committee was also drawn to this particular area of debate, discussion. That area is, how are you going to deal with children between the age of 16 to 18 years? It's not something new about which we are talking, because if you have heard the earlier speaker, she was talking about how the age of consent keeps varying in different countries, and even our 375 had such a provision. It had up to 16 years. So there was a big debate which went on, where the committee's attention was drawn, saying that 16 to 18 deal with them differently. See if the consent has been taken, is there a consent, or was there no consent, etc. So they wanted something to be done for children who were falling within the bracket of 16 to 18. Ultimately what happened was that the committee felt that it will once again expose the children. Please keep in mind that this was all happening at the period when there was a lot of hue and cry from the public saying that children are being abused and you don't have a law. So the committee thought, if that scope of 16 to 18 is given effect to, you are going to go back to the same 375. You are going to go back and again ask the child about what all experiences it had during that particular sexual abuse or sexual attack that was made on the child. So the committee said, no, let us not get into it. So ultimately they decided that it is going to be 18. So consent, no consent, 18 and below, it is going to be an offence under the POCSO Act. So the committee ultimately said that once a child is under 18 years of age, the element of consent will be irrelevant, was how it was concluded. And all of you know that this act came into force in 2000, right? So we are now in 2023. An act, any enactment must basically go in tandem with the realities of the society. Meaning, you cannot have one act and you cannot have the society going in a different direction and the object of that very act getting defeated because of the situation in the society not in consonance with the prevailing act. So, a situation has come where we are attempting to relook, we are attempting to think about what has actually happened in this act, who was the target group in this act, and what was the reality, is where I am coming to. So, after all this, what had happened was I said that the committee had clearly put a lid saying 18 and consent is irrelevant. So, basically two elements weighed in the mind of the committee. One is the element of consent should be treated as irrelevant under 18 years, and this would be in consonance with the objective of the UN, that resolution. 1, 2. Consent, this is very important, this is very relevant even now. Consent raises an issue of re-victimization, since the victim becomes the focus of a cross-examination to determine whether the exception applies or not. If you give that elbow space, then that 16 to 18 will once again get into what happened, how happened, what did he do, how did you respond. All these things the committee was totally against. So, this is how this act came into force. My dear friends, if you really want to appreciate what I want to say, you have to have some knowledge of science in this. Without understanding the science, you cannot understand what I am saying, number one. Number two, without looking at it from the perspective of an adolescent person, you cannot understand what I am saying. At the age of 55, if you look at it, you will look at it from a very different perspective. But if you look at it from the age of 16, 18, 19, 20, the perspective will be very, very different. And to understand that perspective, you will have to know some science. So, I am not going to bore you, but I am going to say that you have absolutely no control because of the types of things which are happening in our brain and body. So, I will get into the science for some time. See, basically, when it comes to the science, the adolescence can basically be divided into 3 stages. It can be divided into 3 stages. The first stage is called as the earlier adolescence. That earlier adolescence is between the age 10 and 13 years. 10 and 13 years. There is something called as the middle adolescence, and that middle adolescence is 14 to 16 years. And late adolescence, which is 17 to 19 years. You have to understand this. Probably you have avoided science and you had joined law, but science will keep on chasing you like this. There is no escape from science, because if you don't understand science, you will never understand this. There are lots of areas like that in law, and this is one very important area where people continuously try to bring in the so-called culture into it and confuse themselves. Therefore, you have to understand the science, and then you decide for yourself as to whether how much control an adolescent has, right? So, I said there are 3 stages. The early adolescent is from 10 to 13 years. From 10 to 13 years, if you look at it, this is called as the hypothalamus. This is the villain who starts this. This hypothalamus, which you see in the screen, it plays a big role, huge role in stimulating the production of sex hormones. So, if you don't want to get into it, remove your hypothalamus, you will be normal. But if you have a hypothalamus, then the problem will start at this age, this earlier adolescent age. So it stimulates the production of sex organs, and you know these two things. One is the testosterone and the other is estrogen. That testosterone is from the testis, estrogen is from the ovaries. I will make it as simple as possible. I don't want to conduct a science class as the last speaker here. So this is the one. So that's the next one. So that's how the stimulation happens, and that's how that urge starts coming. Meaning it's millions and millions of years human being has gone through this, and this is all done for the purpose of reproduction and for the purpose of thriving in this world, to have the next generation to go to. And that's the whole purpose of this urge. This nature has done it only for that purpose. The nature did not have any perverse thinking in it. The nature wanted to establish that the world thrives, that the population comes. So that's how it happens. So I said that the testosterone and the estrogen from the testes and the ovaries, and this stimulation happens from the hypothalamus. This testosterone and the estrogen, they are contained in high concentration in amygdala. I think I spoke about amygdala some time back. Amygdala is this small lime-like portion which actually is the seat of emotion for whatever we do. Everything happens because of this amygdala. So this amygdala is the testosterone and estrogen which are contained in high concentration in amygdala and hippocampus. Please put the third one. Yes. Look at this. So this is how it actually happens, and you will also find something called as the prefrontal cortex, about which I will tell you in another 2 minutes. So this is what happens at the pre or earlier adolescent stage, right? So when this happens, this amygdala and hippocampus play a very pivotal role in the context of a teenage romance, since they are exceptionally sensitive to behavior, induction and pleasure, etc., right? Then comes the middle adolescence. The middle adolescence is between the age of 14 to 16. Insofar as the middle adolescence is concerned, the experience of a strong sexual drive happens during this period, this middle adolescence period. What I am saying is that these are things which are happening inside the body over which you do not have a control, right? So it's happening, and I said that for the present I am not going to talk about prefrontal cortex because there is a reason why I said it. So this is happening. Nature has built us in a particular way where it starts giving these impulses into us, and you cannot go and just pick your hypothalamus and throw it away. Meaning it is happening, the changes are happening, the hormones are secreting. Because of the secretion of the hormone, there are certain stimulants that are happening in the body. Then comes the last stage, which is the late adolescent. So this is this period, this late adolescence, I said, is the period from 17 to 19 years, and there is a sort of maturity that is involved in this period. From 17 to 19 years, some sort of a maturity is available. Then, insofar as the hormones that are triggered, I told you that hormones are being triggered during this adolescent period. They produce broadly 3 types of impulses, which is one is lust, second is attraction, and the third is attachment. So one is lust, second is attraction, third is attachment. This is how I have broadly put it. Prefrontal cortex is the one which completely matures at the age of 23 years. And if you had carefully listened to Justice Dhammaseshadri Naidu in the morning, he was talking about when you use it more, it grows. If you stop using it, it shrinks, is what he said. And that's exactly the most vital portion of why we are a human being, is only because of this. And the complete maturation actually comes at 23 years. Therefore, that is one more factor which actually is disadvantageous to persons in that age group, because they do not have this complete capacity to take a complete thoughtful decision at that age. Apart from the secretion of hormones, this is yet another factor which does not, or which makes them incapable of taking a reasoned decision. Please keep that in mind, because all of us who are sitting here, I think so, we have this prefrontal cortex. How far we have it, I do not know. But and if that's why I said you should not look at it from this position. You will have to look at it from a position where there is a secretion of hormone and you do not have the fully grown prefrontal cortex. That is how you will have to look at this issue, correct? Now, going into this, I said there are three impulses which comes out, which is the lust, the attraction and the attachment. So I have put it, I thought that more than telling you the words, the complicated words, you can look for yourself. What are those things which actually sort of pushes that particular type of emotion? For the lust, those are the two, and for the attraction, those are the three, and for attachment, those are the two. And this last one, this oxytocin and vasopressin, this oxytocin and vasopressin are the hormones which are very closely associated with what Madam said, the Romeo-Juliet issue. That's the one which is closely related to that romantic love. The last one, which I said, the oxytocin and the vasopressin. This understanding is very important. Unless you know this, you will never understand why certain things happens at that age and why that impulse happens. And please keep one thing in mind. Again, that also Madam said, the exposure that we had and the exposure that the present day children have is very, very different. I used to tell it jocularly that waiting, since I have also undergone all this, waiting in a bus stand with a girl sitting in a bus 200 meters that side in one corner seat, she turns and looks at you, 3 days it is enough for you. That is the distance with which we used to look at girls. Right? When I am speaking it, I should not be speaking from here like some sage. Since everybody has undergone, somebody has to admit as to what he underwent. I don't have the shyness to admit all these things. Right? If I have that, I cannot even discuss about it. So, that was enough. And that's the maximum amount of exposure you can have. Or probably she is in that corner of the street, you are in this corner of the street. Those were the type of exposures which we had. Today, what is the type of exposure you have? You have given a Satan into their hands. And one touch into it, you get lot of things out of it. Please look at the challenge. Already they are gripped with this hormonal problem. They don't have the complete formation of their brain. Their prefrontal cortex is not allowing them to think for themselves. Apart from that, this Satan kindles them. So what happens is that they try to explore it. They try to get into it because it gives them a very congenial atmosphere. Today it is not very difficult for a girl and a boy to meet. Even though I feel very sad about it, but then since I did not get that opportunity, that's fine. But in any case, what I am saying is, if that situation arises. Now, what I am saying may be a big joke. Now comes the danger, right? So we have gone up to that. Then a situation comes, an atmosphere is created where they get into a sexual act, right? Let me be very frank here. If many of us had fallen under that situation, we would have been convicted under POCSO. This is not joke. Please understand the science behind it. Please understand the type of changes and things that can happen within your body, which is completely out of your control. And a situation is also created. The world is creating a situation, your gadgets are creating a situation, and today father, mother goes for work. See, so many things are happening today. So it's very easy for a boy and a girl to get together is what I am saying. That's exactly what I am saying. If that situation was there even earlier, I am sure that there was nothing new that would have happened. This hormonal changes, this and all is happening for millions of years here. So please have this in your mind. Probably what I said would be very gross to you. But as a last speaker, you will have to put it in such a gross manner just to keep you awake. Just to make you think as to what this man is suddenly coming and saying. So this please keep in your mind. So there is a natural relationship because of this attraction. This natural relationship which is involving two persons in their teenage becomes notorious. When it becomes notorious, when the relationship transcends this platonic limits and it gets into the realm of sexual relationship. That is where the problem is. When it comes to this adolescent relationship, as one of the earlier speakers said, there is a conflict between a factual consent and a legal consent. This is exactly the real conflict. Right? Having understood this, what is the object of this POCSO legislation? That is very important, because I said the committee was formed, they gave recommendation, this, that. What is the object of the POCSO legislation? Protection of children from 1. Sexual exploitation, 2. Sexual abuse. I will again repeat. Protection of children from sexual exploitation and sexual abuse. This is the whole object of POCSO enactment, right? What is the ground reality? We are now talking about the ground reality after more than 20 years after the POCSO came into effect, and it is our duty to talk about it because it involves child's right. It involves children's right. So we have to talk about it. It's very important. What is the ground reality? What is the majority of the people who are booked under this act, who are charged under this act? In a 2017 study that was conducted in Tamil Nadu, this was conducted by Indian Council for Child Welfare. They took 118 cases apprehended under the POCSO Act, out of which 53 cases, which is what? Something like 45%? 45% was the case of elopement and love affair. 45% was elopement and love affair. This is a 2017 study. What did I say? The object of POCSO was to protect children from sexual exploitation and sexual abuse. Correct? Keep that in your mind. See what is happening in reality. Is it going in that direction, or the whole purpose of this enactment is getting defeated, is what you will have to think for yourself. So this is one study. There is a study between 2013 to 2015 that happened in Delhi. There, out of 526 complaints, 28% are adolescents between the age group of 16 to 18 years, and it resulted in 90% acquittals. 9-0. 90% acquittals. Either because the girl did not support, or because they were not prepared to come to court, or they said that we want to compromise, whatever was the reason. 90% is the acquittal. Look at the amount of energy that would have gone into these cases. Apprehending, arresting, producing before magistrate, remanding, the boy undergoing this. There is a lot of problem that happens on the girl side. They are all destroyed, and ultimately the person gets acquitted. Right? Now, 2022, there was a study of POCSO cases in India. That study was conducted in 8 states. Totally 8 states that study was conducted for the periods 2014-15, 16-17, then 19-20. In all cases of consensual relationship, 95% of the cases ended in acquittal. These are staggering figures. These are not small figures I am talking about. These are really staggering figures. Then, in 2022, 1,715 decisions involved romantic relationship by the special courts from Maharashtra, West Bengal, Assam. This was analyzed. There, 93.8% ended in acquittal. So, what is the ground reality? What are these numbers telling us? It is very important to know. What are the numbers telling us? One, the ground reality is that first, using the criminal law to regulate adolescent sexuality is futile. Going by the acquittal rates. It's a futile exercise. It's lot of energy consumed, lot of families destroyed, lot of time of the judiciary has been taken, and for what? For showing acquittal in all the cases. That is number one. Number two, it is actually overburdening the criminal justice system. Like how the 138 finished off the criminal justice system, and the people who are doing 138 cases suddenly thought that they are criminal side lawyers. This POCSO has virtually overburdened the criminal justice system. And obviously, you know the type of hype that goes on. We have our WhatsApp and this and that, and you keep on writing stories after stories after stories, and ultimately all that is acquittal only. Then the third is, by the time it ends in acquittal, in any way, in the trial court or it is quashed by a high court under 482, the life of an adolescent boy comes to a grinding halt. Now look at this case. There is a quash petition that comes up before me. I look at the quash petition. The petitioner is the complainant. So I thought it is after lunch and probably I am not awake. Again I saw the petitioner is the de facto complainant. Then I slowly asked the lawyer, complainant is the petition? Yes, my lord, complainant is the petition. I said, I have never seen a complainant file a quash petition. Normally the accused will, no, my lord, complainant is the quash. Then I said, is the complainant here? What is the case? The counsel said it's a POCSO case. So the mother was there. The mother straight away told me that என் பொண்ணுக்கு அந்த பையனோட ஒரு பழக்கம் இருந்ததுங்க. இப்போ என் பொண்ணுக்கு கல்யாணம் பண்ணி வைக்கணும், நீங்கள் அந்த கேஸை குவாஷ் பண்ணுங்க. Stunned, that's how she dictated me. She said, அதெல்லாம் குவாஷ் பண்ணி என் பொண்ணுக்கு நான் கல்யாணம் பண்ணாங்க, இந்த கேஸெல்லாம் வச்சுருந்தா நம்மளால் பண்ண முடியாது. Then I said, you please ask the girl to come. Then the girl came. See, this is where the reality strikes you. The girl comes. I asked the boy also to be released on interim bail, exercising my 482. I asked the boy also to be produced before the court. Then the girl comes. I call that girl. That girl tells me, that girl is something like 17 years or something like that. That girl tells me that ஐயா நான் ஸ்கூலுக்கு போயிட்டுருப்பேன், இவர் வந்து ஆட்டோ ஓட்டுறவர் அந்த இடத்துல, அப்படியே ரெண்டு பேருக்கும் பார்த்து பழக்கமாகி போச்சு. எங்கள் வீட்டில் கல்யாணத்துக்கு பார்க்க ஆரம்பிச்சிட்டாங்க, இந்த விஷயம் தெரிஞ்சு போச்சு, எங்கள் வீட்டில் கல்யாணத்துக்கு பார்க்க ஆரம்பிச்சிட்டாங்க, அதுக்கு மேலே முடியாதுன்னு நான் ஐ ஃபோர்ஸ்ட் ஹிம். ஐ செட் யூ டேக் மீ எல்ஸ்வேர். Then that girl tells me, அவர் எவ்வளவோ வானான்னு சொன்னார் என்கிட்ட. அந்த பையனுக்கு வயசு 20. அவர் எவ்வளோ வானான்னு தான் சொன்னார். வானா, நான் ஆட்டோ ஓட்டின்னு இருக்கேன், இன்னும் நான் வாழ்க்கையில் செட்டில் ஆகணும், ஸோ ப்ளீஸ். ஐ செட் நோ, யூ ஹாவ் டு டேக் மீ அவே. த பாய் வாஸ் ஃபோர்ஸ்ட் டு டேக் திஸ் கேர்ள் அவே அண்ட் தி ஹார்மோன்ஸ் play their game. Then both of them are caught. Boy sent to the police station, sent to the jail, and he was inside for 7 months. It was at the stage of for quashing of the charge sheet or something came before me. Now I see the boy, pathetic. He is an auto driver. He is eking his livelihood from that. And the boy has no idea as to why he was arrested, why everybody is looking at him like some criminal. Then I call him and he tells me the same story. He told me the same story, and that is how I wrote that Vijayalakshmi judgment. It really struck me because before me, Justice Parthiban wrote an erudite judgment. I consider it one of the most classical judgments on POCSO, and everybody must read that judgment. It was an eye-opener even for me. It was such a classical judgment. In his own style, he wrote that judgment, and that was a big inspiration for me to write the Vijayalakshmi judgment. But that is where the reality strikes you. Then, of course, that judgment was written, and you will find that across India, it has been followed now. Across India it has been followed. Today it is pending before the apex court for a final decision, because today the problem is that we cannot legislate. We can only try to help out people. We cannot legislate on anything. So what happened was that a POCSO committee is there, already formed with the judges. We had an interaction with the police. Then we told the police that whenever a case of elopement or this love affair comes, kanmuditanama, don't go and arrest them. Meaning, for every case, don't arrest is not the solution. Give them a summon under section 41A of CRPC. On a case-to-case basis, you decide. After that was done, we had a series of meetings with the police officials and all that. The arrest rate has come down. And the second instruction which we gave was, please don't imagine and write something. All their perversity will come in that 161 statement. Because they have so many things in mind which they were not able to do. So they will write all that in their 161 statement. So we said, don't do it. You are going to write exactly what that girl is saying. Which means that what is recorded under 164 and what is recorded under 161 will be in tandem. Right? If that is in tandem and some consent is there, we said there will be some mechanism, let them come before the High Court. We are all sitting readily for that in 482. We'll call them, and we kept quashing one after the other. In almost all my brothers were regularly following it, because everybody was concerned about it. Everyone was concerned about what was happening. So this is one mechanism which we have followed in Tamil Nadu, which has really brought it sort of under control. But these are all temporary mechanisms. This does not really cure the real problem that lies. So the next question is, I have told you what the problem is. So the next question is, do the boys and girls falling within this bracket, do they have any rights at all? That's the next question. What are we talking about? What rights are we talking about? I have identified some rights. The first right is autonomous choice to be in the company of one another. This right is traceable to Article 21 of the Constitution of India, and this right has been spoken by the Supreme Court in the case of National Legal Services Authority case, that is in 2014 5 SEC page 438. This judgment deals exhaustively about this autonomous choice to be in the company of one another. Then second, right of dignity and privacy. We think that we have the right to go into the life of somebody else and thrash them and finish them off. Just because they are aged about 17 years, 18 years, 19 years, we take that right in our hands because we all think that we are angels. That's the problem. The problem is that we all think that we are angels. We never had any such thought, and we are next to God. Most of us are scoundrels. Fortunately, we were not caught. So, let us, when we decide cases, when we think over these cases, let us face reality, let us put ourselves into that position and then think about it. So, the second right that is undermined, according to me, for adolescents is their bodily integrity and dignity under article, which is again traceable to article 21 of the Constitution of India. We'll have to trace it for somewhere. It is traceable to article 21 of the Constitution of India. Then, third is depriving the liberty of the adolescent boys. See, you arrest boys who are under consensual relationship, and the boys are treated as boys or child in conflict with law. The girls are treated as victims of crime. Recently, a case came before us in a bench where this boy and girl studying in some school, this boy ties a tali in a bus stand, right? These students took photo and they started sort of forwarding it in. The society said, where are we going? We are going nowhere. Some playful thing has happened in a bus stand and that boy was aged about 16 years. That girl was aged about 15 years. That's all. They went to the house of that boy, arrested him, took him to the JJ court, kept in the home. After this was brought to our notice, we released them, and that's where we said that we want to have a dedicated bench for following up these cases, because he is going out of, and boy is now he is now dealt with under JJ. Boys, please understand, under POCSO, child is gender neutral. Child is not just girl child. It is gender neutral. But the boy is dealt with under JJ Act. The girl is the victim under the POCSO Act. That's the problem. So we had to call that case, quash it. Meaning we like that. Meaning we keep on quashing like that. But what happens during the interregnum period? That boy's education is gone. The society sees that boy like some Hitler. I do not know what more will happen. Obviously, they'll have to move away from that place and stay elsewhere, because in and around people are going to say that in the vayasula idella eppadipa nee panna idella nyayama irukku. See, that's the reaction which the society is going to give, correct? So it deprives the liberty, and in many cases the girls don't want to go with their parents. They are sent to their homes, and I do not want to say much on these homes. It is pathetic, to say the least. So to that extent their liberty is deprived, again traceable to article 21 of the Constitution of India. Then the fourth one is right to sexual and reproductive growth. This gets deprived particularly because of the mandatory reporting under section 19 of the POCSO Act. So this was yet another lesson which we learnt, and I learnt it more from my brother Justice Satish Kumar. You know, in Nilgiris that these todas, the people who are tribes, they get married at 16, 15 and all that. So what used to happen is, after marriage, the girl will become pregnant. She will be brought to the government hospital. Government hospital under section 19 will inform it to the police. Police will arrest that fellow, and suddenly that fellow will find himself inside a jail. He will be thinking, I married, meaning she became pregnant. Why are they arresting me? And not one or two cases, my dear friends. Almost 800 cases. So all of a sudden, Nilagiris had pendency of something like 920 cases or something of POCSO. People were looking at Nilgiris as something like any child goes out is raped. And the reality is, then I spoke with my brother Satish Kumar on this. Then he inquired, because he hails from that place. He inquires, and this is what we find. And I was told that some cases were quashed. It was filed and quashed and all that. So this is where the right to sexual and reproductive growth that goes. Meaning, then they ask for 19. If they don't inform, then that is an offence punishable under the POCSO. Meaning, if you don't report, you are finished. If you report, they are finished. That's the type of provision which you are having in POCSO. And there was a similar provision in South Africa. this is how I wanted to conclude it. There was one similar provision that was found in South Africa. That was a case called as Teddy Bear Clinic for Abused Children case. Teddy Bear Clinic for Abused Children case. You can find this in 2013 SEC online. ZACC page 35. They had a very similar provision, which is section 15(1) of the Act. So it is almost like our Indian provision only. They went into all these things, and what was held ultimately was that, I'll just read that portion only. There can also be no doubt that existence of a statutory provision that punishes forms of sexual expression that are developmentally normal. Please look at these words. I told you how the development takes place. Developmentally normal degrades and inflicts a state of disgrace on adolescents. To my mind, therefore, the stigma attached to adolescents by the impugned provision is manifest, and it was quashed. It was held to be unconstitutional then. So, other countries are also having situations like that, and they are dealing with situations like that, because at the end of the day, across the world, everybody is going to have this hormonal problem. It's not going to be peculiar to India. This is a universal problem. Anybody who is born as a human being will have to go through all these things. So this was the type of reaction that happened or took place in South Africa. So what is the way forward? How is it that we have to deal with it? I'll just say that and leave it to your thought. According to me, one, the age of consent. Now we have a 22, 23-year-old, 22 years of experience in this. I have already told you where it all led to. So my first suggestion is that the age of consent, which is the definition of a child, must be reduced to 16 years in India, so as to bring the consensual sexual relationship, including minors, outside the purview of POCSO Act. See, the reason is, I had this data as to what is happening in other countries, but the previous speaker has already given you the complete data as to what was the age of consent in different countries, in France, USA, this, that. You will find that it is all averaging 16, 15, 14. There are countries where it is 14 also. So 16. That is number one. Number two is, this is very important. Number two is the closing age exception. This is something to be taken into account. There are countries which says that children who are aged about 12 years, the age can never be below 12. Meaning that's not the age where even adolescence starts. So about 12 years, and the gap between two adolescents, two persons who had this consensual sexual relationship is not more than 3 to 4 years gap. You understand? Meaning 16 years, 20 years. Something like that. 3 years, 4 years gap. Because even there you are under the grips of that. You have not really moved out. And that's a very natural attraction which comes. Correct? So they are now getting into this issue of closing age exception. There are countries which are following it. There are countries which say 4 years, 3 years, 6 years. So that a person of 30 years does not take advantage saying that I had consensual sexual relationship with a 16-year-old girl. Meaning, so understand that you must put both of them in that plank and understand it. Or else it will be misused. So therefore this is another safeguard which can be brought in. Then the third is, the person with whom the consensual sex happens must not be in a position of trust or authority. Meaning, a person who is a close relative, a person who teaches, who is a teacher. Today we find 21-year-old teachers and all that, right? 20-year-old. In engineering colleges, since it's all temporary appointment, it is 20-year-old teacher only. Many cases. They get attracted. He is in a position of trust. He is in a position of trust. This happens too much in gym trainers because of their proximity to that girl. So again, you cannot say that it is consensual, meaning that's a position where he is under authority and probably she goes there for something and this fellow misuses it and he knows exactly how to misuse and build the confidence of that girl. It happened very recently in one of the cases. The girl comes and tells us that gym trainer is already married and he has 2 children. She says, in spite of it, I will go only with him. She was 17 and she says, even if you make me go with my parents, 18 I will go with him. Then my brother who was sitting next to me said that don't put the next question. If she asks some terrible questions, then you will be caught. He said, you better start dictating the order. Don't ask her one more question. See, problem. We do not know the way in which she was responding in court. The third question, she was almost here. Then the brother said, don't put any more questions, this is enough. So, the third criteria which can be seen is consent given by a person who is in a position of trust or authority. Trust or authority. Then, the fourth thing is that sensitive issues committee must be appointed. There must be a committee it was a committee which had started, which deliberated, which took into consideration the recommendation that was made by the parliament, and then it at that point of time said that no, let the 18 be there, let the consent, no consent, now the committee must again come into the picture and they must again get into this by looking at data all across the country, and the committee must work into it and deliberate in all these things. And last but not the least, the right of the adolescents for a consent to have that right of where they have an affair because of the biological changes must be recognized. You have to look at it from the point of view of science, or else there is no way you can really get in control of this. So with this, I thought I can finish my speech. Thank you.
Thank you, Lordship, for clarifying the integration with scientific approach. I would like to invite Ms. Preetha to come over to the dais to give her understanding about the topic.
Distinguished guests, dignitaries, advocates and students, good evening to one and all present here. I am very much honored to present my observation on behalf of the audience to the star speaker. At the same time, my cortisol level increases because I am in the middle that I couldn't enjoy the science class which Lordship taken as we enjoy in our school, like when the adolescent chapter comes, every boys will be and every girl, oh, this is the thing I was expecting. And in the meanwhile, I am to take the notes for my presence of speech also. Thank you, Lordship, for your intellectual insight into the nuances of a very common yet traumatic experience which the children are facing today. Though the POCSO Act has been in existence for more than a decade, its effective implementation has taken momentum only after the interpretations given to the provisions by the judges of various honorable high courts and supreme courts. One of the most important delegate aspect of the act is the consent, which is given by a child to the perpetrator without realizing or understanding the gravitas of the act committed. And it is often repented by the child when it becomes an adult. Lordship beautifully held the aftermath of such consent given by the child, not only by the child, the aftermath which caused to the boy also, which is a grey area. And Lordship meticulously held the issue even by citing the citations, but Lordship didn't do like giving full stop or comma when he used to give in dictations. And Lordship explained it in a more simple manner so that everyone can understand this. Lordship had traveled with this issue from Nilgiri to South Africa, United States, Tamil Nadu, like so much of meticulous aspects he has been dealt with, which is very difficult to summarize in this 2 minutes of opportunity I've got. Yet, the analysis given by your Lordship today would be of immense assistant to the people present here and also to those who hark it through the social media. We only wish that the message conveyed by your Lordship reaches all these stakeholders and police members and members of Child Welfare Committee. We wholeheartedly thank your Lordship for having been dealt with the important aspect of the POCSO Act. I want to re-quote the quote which is quoted by the father of modern South Africa, none other than Nelson Mandela. There can be no keen revaluation of the society's soul than the way in which it treats its children. I especially thank my senior, beloved senior, Srinivasa Raghavan sir, for giving me such a wonderful opportunity to present my observation over here. Thank you one and all present here. Thank you so much.
Thank you, Preeta, for your wonderful feedback. Thank you, Lordship. Thank you, Chairman, ma'am.